Thank you.
SJC-11193, Belanger versus Essex Probate Court.
A little piece of it. Can I have two? Yeah, thank you.
Good afternoon.
Good afternoon, Chief Justice Ireland. May it please the court. My name is Lisa Siegel Belanger. I'm an attorney. I am the underlying petitioner in the original action that I brought before the single justice, asking for extraordinary, immediate, and urgent relief having to do that with conduct and irreparable harm based on, as we speak, having a risk of mortality of my 84-year-old father, who has been an attorney for over 50 years, practicing in Massachusetts. Before I approach the substantive matter here, I would ask that I be allowed to address three points that are very big concerns concerning procedural aspects in this case, at least in causing a reason for inquiry. As recent as last night when I looked on the docket sheet for this case. So if I may, I would like to please address those.
Let me just say, you have 8 minutes and 21 seconds. You can use them as you wish.
Thank you, Your Honor. When I looked on the docket sheet last night, I noticed that there was no appearance of counsel that had been originally placed there by Attorney Costello. Attorney Costello specifically represents Attorney Cuffe and Attorney Feld. There are 6 other defendants. And the only person that so he had placed his general appearance in June of 2012, and when this court said that it gave notice that it was going to have it placed for argument in January, Attorney Costello emailed and sent out a letter to all counsel, sending a letter directed to Susan Mellon, stating that he would be appearing and arguing on behalf of specifically Attorney Cuffe and Attorney Feld. And when I had previously looked on the docket sheet, that letter of his appearance had been on that docket sheet. But as of last night, there is no indication that that had ever existed. I would submit that if Attorney Costello had changed his mind, that he did not want to argue, that what would have happened is that he would have submitted a letter stating to that effect that he has changed his mind and has decided not to. I would submit that the deletion causes concern because that, I would submit, as mineral law, is part of the record. And as I stand here, Attorney Costello, was here today. I'm not sure if they're here now. I don't want to direct my attention, but all of the defendants and Attorney Costello, and I don't know, with the exception of from the Attorney General's office of Martha Coakley, Attorney Porter, I don't know what he looks like, so I've never met him. So I don't know if he was here or not. So there's another big concern, the fact that Attorney Kazarosian had specifically written a letter to this court stating that she, in fact, was not submitting a brief, and before doing so, she had made a call. So if I could reference, I had the docket sheet I printed out from last night, and there's also another thing that was changed on the docket sheet. When Attorney Kazarosian had informed this court that she was not going to argue, I have a previous docket sheet that says no extensions allowed. That no longer appears on the docket sheet either today. I'm asking, I would request, given the fact that it was represented to me, that counsel was, that Attorney Costello was going to be arguing, that I request that I be allowed to actually have additional time based on that representation and not having also informed that he would not be arguing. I also just remembered that the sign-in book actually shows that that they were here, at least in terms of Brian Cuffe and Max Barrett. So I would, if needed, I would request that I be allowed to have additional time, especially given the import of this.
Ms. Belanger, you have 10 minutes. Okay. You haven't gotten to the merits yet.
Well,
now I don't want to be unfair to you. I understand your concerns, but I don't think that we can extend additional time to you, so you're going to have to start to talk about the merits of the case.
Well, thank you, Your Honor. I will respect that. And I think respectfully that that does go to the merits of this case, because this is what this case is really all about. And it's about a year and a half worth of unethical, unlawful, unprofessional conduct that has been raised before the probate court, lower court, consistently and repeatedly over a year and a half. And thankfully you did indulge me, Justice Island, and so I think the most appropriate thing for me to do actually is to be able to, I had actually written a poem for my father. I have not seen my father for over a year now because I have been viciously and maliciously, wrongfully attacked because I have the ability to try and protect the rights of my father. My father deserves dignity. All due process has been, he has been stripped of. And the single justice shows that has erred, irreparably harmed. I cannot get back this time that my father, I proved in court that their only diagnosis by the expert witness is that he suffers from Alzheimer's and dementia, and they are giving him massive doses of antipsychotic medication. And I have consistently and repeatedly have asked for evidentiary hearings before Justice Aber. In fact, on December 11th, I showed that Justice Aber had not disclosed that he had a prior conflict with Mr. Feld. He had Mr. Feld in 2008 in another case. He was co-guardian. They did not disclose that to me or anybody, nor did Attorney Garmiel, who was counsel for Whittier, did he reveal that he also had the conflict of interest, that he represents Brian Cuffe. In another matter...
Let me interrupt for a moment. Now, did you present this to the single justice?
Yes, Your Honor, I did. I presented a petition, Your Honor. In fact, this is my concern, and why I want to bring to this, ask the source, because this is the only way that I can get the truth. Because I have presented 2 motions in June, May and June, that I asked for the stay of the lower court proceedings. Specifically, I gave a 74-page brief with a CD of actual taped recordings, so no one had to rely on my credibility. No one had to determine whether I was telling the truth. I presented transcripts. I specifically laid out the fact that I had no other alternative method to be able to see my father. I've already lost so much time since May.
Now you're going to have to start to wind down now. You're already over your time limit. I note that you have presented us with a 50-page brief. We have it right here. This is your brief.
Yes, it is.
And so we will read every page of this, but you're going to have to wind up now.
Okay. I would submit that the fact that there were no briefs filed by the appellees were in the original petition and the appellate brief, that they were given notice of exactly what conduct they are accused of, and that they, as a matter of law, had a duty to deny or admit, and that because they did not do so, it should be deemed to be admissions. This case, Your Honors, I respectfully, 15 years of appellate practice, Your Honors, because my father taught me to advocate, and I am being improperly punished because I am fighting for my rights and because I know my rights. And the unfortunate thing is, the most important thing I need for the bench to know, this is not an isolated case. This is the day in and day out of what is going on in the court's own 2003 with the Moynihan Report. Things are not better. They are progressively worse. There is a systematic problem. Pro se people are the largest population in the probate court. And with my own observations, fortunately, I think, I'm not sure, that I have the knowledge of knowing what my rights are. And so these people don't. And this is not an isolated incident. These people are targeted. And so I am urging, please, I submitted in my petition, I submitted in my appellate brief that I am asking, please, for immediate relief. There is no restraining order in existence. There is no protective order. And I would please request that the relief be given to me that I have asked for, and that I be given a hearing date, and that I be allowed to have discovery and to conduct depositions.
All right, thank you very much.
Thank you.
Appreciate it.